People versus Omar Johnson.
Good afternoon. Benjamin Rutkenbeck.
Give counsel just a second to sit down there. Go ahead.
Good afternoon. Benjamin Rutkenbecker, Center for Appellate Litigation, on behalf of Omar Johnson. I'd like to reserve 5 minutes for rebuttal, please.
Okay.
This court should review Mr. Johnson's preserved Second Amendment challenge and reverse his conviction. To begin, this court should hold that Mr. Johnson's claim presents a non-waivable issue.
Counsel, on that question, I struggle to make sense of the exceptions in Seaberg, and maybe you can help explain why you think they weigh in favor of finding a waiver here non-appealable. I think perhaps we could set to the side challenges to the voluntariness of the waiver, because that, I think, has to do with capacity, perhaps so too with competence. And if we look instead, there's double jeopardy, right, in which a waiver is enforceable, and that arguably goes to the power of the court and its ability to exercise that power on the defendant in front of it, right? On the other hand, illegality of a sentence is something for which you can proceed notwithstanding a waiver. But when you look at the cases that Seaberg cites for that proposition, they actually look to me like they are cases that sound in coram nobis and have to do more with collateral relief. So what is your best case for the proposition that just as there was, by analogy, there was non-waivability there should be here?
Right. So I can answer that in a few parts, Your Honor. First, I think I agree the court has articulated the standard in several different ways since Seaberg, but all sides appear to agree here that really the core of it is public interest. And so I think People v. Muniz is a helpful starting point in that regard, that claims are non-waivable where they, quote, implicate a public policy consideration that transcends the individual concerns of a particular... But
the only case I can find where we have actually held a case an issue non-waivable on that basis is speedy trial, right? That's I think, Blakely, am I right about that?
You're right, Your
right?
Honor.
And there, the court says the public interest is so strong that it may even be in opposition to the defendant's interest, right? I'm not sure that that's so with respect to a constitutional challenge.
To clarify my answer, Your Honor, Blakely is the constitutional speedy trial case, but that's not the only case that has invoked the public interest. Rudolph is a recent example of this court invoking the public interest to say that the public has such an interest in courts making a determination as to whether a young person is going to have a conviction for life, that is a non-waivable issue. And so that is the standard that has most recently been cited by this court.
I thought maybe Rudolph turned more specifically on the statute issue there, but perhaps I'm not correctly recalling it.
That's the Attorney General's argument here, Your Honor, but that's not what Rudolph says. Rudolph says that this is it's in the public interest, and the court later confirms that Rudolph did in fact hold that claim that a court failed to make a youthful offender determination.
I take your point that there's a public interest, and I'm sure there is, in understanding whether a statute is constitutional or unconstitutional. But Seaberg also seems to me to suggest that there's a pretty significant thumb on the scale, if you will, in finding appeal waivers enforceable. So I'm trying to understand what is it specifically. Public interest, perhaps, one might think sweeps a little broadly. So what is it specifically about the constitutional challenge?
Right. So that's where I think Muniz is helpful, because it talks about public policy that transcends the individual concerns of a particular defendant to obtain review. So if you take double jeopardy, for example, really that is a pretty individualized claim that one person cannot be prosecuted again for the same conduct. So
would you include then an as-applied challenge?
I would personally, Your Honor, because I think that is a line that this court could draw.
And I assume a challenge, for example, a vagueness challenge that's a constitutional challenge to a statute.
I think even as applied challenges are going to have that public policy consideration that transcends an individual just asking for appellate review.
Well, but I guess the question, though, is maybe part of the question is whether a facial challenge has a greater public policy interest behind it.
I think Your Honors could certainly draw that conclusion. I personally would not. I think even an as-applied challenge, right, it's not ordinarily as specific as just one individual's conduct. I think any constitutional challenge to a penal law provision concerns the behavior that anyone in society can engage in without the threat of criminal prosecution.
I looked to see whether there were any cases in which we had addressed the enforceability of an appeal waiver on a constitutional challenge from Seaburg to the President. It's a lot of time that's passed. I couldn't find anything, and I don't think I saw something in your briefs, but it's a little surprising to me, I guess, that this would not have come up in the meantime. Maybe you have some sense of why that is.
I don't, Your Honor. I don't know why that answer isn't. It's never been given by this court. It could be as simple as leave not being granted on that issue in the past. It's certainly an issue that has split the departments, as we all know.
But very recently, I think. The two cases, I think this one and Benjamin, are of very recent vintage, right?
They are of recent vintage, but we cite in our briefs cases from, over time where the departments have reached different conclusions as to this. The appellate term, second department, found these issues non-waivable, I believe, about a decade or more ago. The first department itself found that these issues were non-waivable in People v. Pimentel.
You say these issues, just so I'm clear, you mean constitutional issues?
Not constitutional issues, broadly speaking, Your Honor, constitutional challenges to penal law statutes. And I think in this particular context, the fairness and finality interests that generally do counsel, and this court has cited to find that most issues.
What penal law statute are you attacking here on a constitutional basis?
We're attacking the weapon possession, 26503. There was an allegation here that
Saying that statute is unconstitutional?
that prosecuting Mr. Johnson for exercising his Second Amendment rights was unconstitutional in this case. That was the claim made
Because of
below.
an unconstitutional licensing regime.
Right, so
But you're not really attacking the penal law, are you?
it is a challenge to this prosecution on Second Amendment grounds. It's not, the argument is not that there can be no valid prosecution under 26503. That is correct. But this is.
But you're arguing no prosecution for possession of gun under the licensing regime that was in place prior to the adoption of the new regime in September of '22, yes?
That's correct, Your Honor. And so as to the waivability issue, that implicates anybody's in society's rights to public carry
Why
in
doesn't
New
that
York.
fall within the Second Circuit's distinction about a challenge that traces back to the penal law versus a challenge that traces back to something else?
I believe that's a question about standing, Your Honor, just to clarify.
Yes.
Happily move on to that. So the Second Circuit's holding in DeCastro is not the operative case here. This falls within the long line of Supreme Court precedents, Shuttlesworth, Staub, and Smith, that hold that an individual does not need to subject themselves to an unconstitutional licensing standard before they can invoke the unconstitutionality of that in a criminal prosecution. I think all sides would clearly agree that there's injury in fact here. And what Mr. Johnson alleged below is that he couldn't be prosecuted simply for failing to submit to this unconstitutional requirement. That's exactly what he alleged. He noted that on A12, A18, that he had a Second Amendment right, that the prosecution could not show that he had been disqualified from exercising this right, and that it was impossible for him to engage in public carry under the licensing provisions at that time.
Did he specifically state that it was the section that Bruin struck down that was the basis for the unconstitutionality?
So he did, throughout the motion practice, cite the invalidation of proper cause,
Right.
but I'll note that on A16, he also he cited to the fact that the Supreme Court's issue with the licensing scheme in Bruin was the unfettered discretion conferred upon licensing officials.
But I
which
take
was-
it your argument on the motion to dismiss. I know you had more detailed arguments. I know your light is on, if I may, Chief. I know you had more detailed arguments that you raised later on in the appellate division, but was essentially that because the regime, the scheme as it stood when your client was arrested and charged included the proper cause requirement, and that requirement was invalidated, that tainted the entire licensing scheme and any CPW conviction as well. Is that a fair characterization?
In large part, I agree with that characterization, but I think the claim was a bit more specific than that insofar as Mr. Johnson argued that he had a Second Amendment right that he could raise as a defense. And so since the Cabrera litigation and those cases that Your Honors heard prior, these motions are being made in trial courts across the state, and it is very common and not at all burdensome for the prosecution to respond to these motions by making arguments that the individual before them, either because of their conduct with the weapon or because of their record, could not actually raise a Second Amendment defense, that they did not have that right. That simply was not done here. There was really it was really not disputed what Mr. Johnson alleged, that he had this right, and that but for a proper cause, that proper cause was the reason why he was being prosecuted, that he could not satisfy that standard.
Where would the burden to establish the defense rest?
So I think the initial burden when attacking a statute's constitutionality is on the defense to meet with a preponderance standard. But Bruin makes very clear that once there's a Second Amendment issue, when there's a statute that regulates second conduct under the Second Amendment, and I think there's no contest that that's what we have here, the burden switches to the prosecution to justify the regulation under the historical tradition test. And the prosecution said absolutely nothing about the historical underpinnings of the licensing regimes here. All the prosecution said below was, I think, the not contested, not truly notable fact that some licensing can be constitutional. But it doesn't follow that New York had a constitutional licensing scheme at the time, and
I guess let me see if I can do it with specifics. So suppose, not to talk about this case, but one of the other many cases you mentioned that are percolating now in the trial courts. Suppose a defendant who had been convicted of a felony previously and so was disabled under that provision of the statute raised a Second Amendment claim. Whose burden would it be then? Would it be the defendant's to say, I don't actually have a conviction, or to challenge the constitutionality of the ex-felon licensing provision? Or would it be the people's burden to prove that the defendant was disqualified under some other portion?
I think Bruin itself answers that question, that the burden is on the prosecution to justify the regulation at issue. And that is what's happening in many cases.
So the defendant doesn't even have to say what part of the licensing statute the defendant is challenging, just I have a Second Amendment right, and then the prosecution has to go through history and tradition for every element of the statute.
No, Your Honor.
Then I don't understand.
So the defendant does have to, I think the defendant does have to specifically allege what's unconstitutional, as we did here with proper cause, and also a reference to the discretion. In addition, it's important to note that we have an explicit ruling here on A39, where the trial court held no other provision was called into question under Bruin.
Why isn't there then a question of severability? So if you focus on the proper cause requirement, which is what I think you did in the motion to dismiss, why isn't there a question of whether or not, we know what the Supreme Court has said about that, right? Bruin is pretty clear. Why isn't there a question about whether that's severable and whether or not the rest of the licensing regime and therefore the conviction can stand, as opposed to, I take it you're saying that the invalidation of that requirement alone means that everything else falls?
So there is potentially a severability question at issue. I think at the time that Mr. Johnson, right, was being prosecuted, he alleged below that he was being prosecuted merely because he didn't have a license to engage in Second Amendment protected conduct. And at the time, I think it's important to understand the nature of the error discussed in Bruin, that at the time of Mr. Johnson's arrest, New York State simply didn't recognize this right at all. So he had no lawful path to immunity here. But even if this court were to find that proper cause were severable, there's still a major issue here of good moral character, which at the time Mr. Johnson was arrested.
But you didn't challenge that in the motion to dismiss. I don't think you focused on that specifically until your appellate division brief, but maybe I missed the reference.
So what we have here, certainly at a minimum, is a general objection to the entire licensing scheme, once again specifically citing the unfettered discretion as the basis for why the licensing scheme was unconstitutional. And we have an explicit ruling on A39 that every other provision in New York State was similar to the shall issue regimes that Bruin approved of. And good moral character, I agree, is not preserved for this court's review as an initial matter, but it's certainly relevant to understanding the trial court's decision. And there was no record support for that finding that no other provisions were called into question after Bruin, particularly where, again, the entire licensing scheme was put at issue here. The prosecution and then the trial court did not apply Bruin at all. They just simply said it didn't address any of these questions, didn't apply the historical tradition test, and had that test been applied, that finding really cannot be supported because—
I'm still not sure what you mean by the entire licensing scheme was put at issue here. For example, the age requirement?
So you're right, not the age requirement, Your Honor.
Then the question is, how do we tell what was and what wasn't?
So again, Mr. Johnson alleged that he was being prosecuted for exercising his Second Amendment rights merely because he didn't have a license, and that the licensing here had been found unconstitutional, that the licensing scheme conferred unfettered discretion to licensing officials. And that proper cause, and in addition, good moral character, had that same issue, that at the time of Mr. Johnson's arrest, his rights were not recognized by New York State.
So you're saying when he alleged unfettered discretion as the constitutional defect in the licensing, that specifically referenced proper cause and good moral character. Is that your argument?
I think when you take that coupled with the court's express finding that every other provision in New York State passed constitutional muster without any application of Bruin's test at all, the lower court's decision cannot be affirmed.
I'm just
on
trying to
appeal.
understand how you put the prosecution on notice of what in the regime it had to defend, or is it, as was posited before, all he has to do is say Second Amendment, and the prosecution then has an obligation to defend every aspect of the statute?
No, so I think what we're alleging is that he cannot be prosecuted merely because he didn't submit to an unconstitutional regime, and that he has a Second Amendment right.
Well, the first part, I think, is maybe sounding in the standing argument, but I don't understand, maybe I'm just making the same point you've heard, I don't understand how we are supposed to ascertain exactly what aspects of the licensing regime. You have said, I think, that it's not simply the case that if a defendant invokes her Second Amendment rights, that then the prosecution must defend, by reference to history and tradition, every single aspect of the licensing scheme. And so if that's not the way it should proceed, it seems like there has to be an explicit identification of what aspects you are claiming are unconstitutional under the Second Amendment. And I take it you're arguing that the reference to unfettered discretion does that, as Judge Canataro said, with respect to proper cause and good moral character, but maybe nothing else?
Yes, Your Honor, especially, again, this might be a different case if the trial court had simply said, right, there were no other allegations, this is just about proper cause. We find that that wasn't applicable, or that the court did, of course, reach standing incorrectly by distinguishing Shuttlesworth and saying he still had to satisfy the rest of the licensing requirements. But here the court went one step further and said everything else was fine under Bruin when it had been signaled to the trial court that Bruin was about more than proper cause. Bruin was about unfettered discretion. And really it was for the court to apply Bruin's historical test, if at least to apply Bruin's historical test, and need to go no further perhaps than to say that only proper cause had been at issue there and that wasn't enough. But the court said, ruled that everything else was proper in New York's licensing scheme, and that's a decision that cannot be affirmed on review.
Thank you.
Thank you.
Good afternoon. May it please the court. Emily Ann Aldridge for the people. There is no principled reason why a Second Amendment challenge must be preserved but may not be waived. Defendant made a knowing and voluntary choice to waive a speculative Bruin claim in exchange for a favorable deal. Going to Your Honor's question regarding Seaberg and the overwhelming theme there. So in Seaberg, the court held, of course, that appeal waivers are generally valid, and in Hidalgo, further held that a general appeal waiver, covers all waivable claims. And Seaberg cited 4 claims that survived the waiver, and they were ID'd for a reason. 3 went to the reliability of the factual determination of guilt. So,
But why isn't counsel correct that there's a public interest in the facial constitutionality of a statute, and that under Blakely, that should be enough to exempt it from the waiver?
because the court has looked at the concern regarding, I'm going to quote here from Seaberg, going specifically to the speedy trial issue. Trial delay may result in the loss of evidence or an accused inability to respond to criminal charges, thereby compelling innocent persons to plead guilty out of necessity. Because of the societal interest, a defendant may not waive such a claim. That's from Pinpoint, page 9 of the court's decision. So the court has made clear, and it also goes into involuntary pleas and incompetency, that again, it's looking at the adjudicative process of determining guilt or innocence.
Well, but
And-
why couldn't you say the same thing about an unconstitutional licensing scheme, that there are some people who met the other requirements but couldn't show proper cause, had a gun, and were convicted, and that forced an innocent person under a constitutional standard to plead guilty?
Well, the constitutionality, this court has ruled many times that constitutional issues may be waived. But more important, if the defendant wishes to raise these claims on appeal, that is part of the negotiation process.
Well, that would be true you could say that for illegal sentence as well.
Well, this is not an illegal sentence
Well, I
claim.
understand that, but we've said that those are not waivable.
Well, but also this court looks to,
Why are they not waivable?
well, here there's a danger of conflating a constitutional issue with an illegal sentence. And claims, and it's essential to be sentenced as provided by law, and obviously there's no preservation required there, but the court,
But why is that obvious?
because that is what this court has held in Seaberg.
I guess I'm trying to get to the theoretical underpinning, right? It seems to me that there's at least an argument that the reason that you can't waive an illegal sentence is because the state is not authorized to punish you in that way. And you could say the same thing about a statute that is facially unconstitutional.
But here the court does have the power to decide a constitutional question, and that was before the court here, this constitutional question regarding the Second Amendment. This court has found that the defendants can waive claims under the Fourth Amendment, the Fifth Amendment. There's a wide variety of claims, and even going back to Your Honor's question regarding the illegal
Well,
sentence.
do you know if we've said you can waive a facial Fourth Amendment claim as opposed to an as applied?
I'm honestly.
For example, a statute that says you don't have to have a warrant to go into people's homes to take things.
Well, that would certainly raise.
That's a facial violation, I would think.
Yes, that would certainly raise
But
significant constitutional.
do we have a case that says you can waive that kind of a claim?
Well, I don't believe that that sort of claim, that is obviously a very different situation. And a
But why is that? I mean, your adversary argues, set aside the merits for a minute, but your adversary argues that the licensing regime and any attendant CPW conviction is blatantly unconstitutional under Bruin. How is that different than the hypothetical that the chief judge is positing, which is there's a statute enacted that is blatantly unconstitutional? It seems to me that either they're both waivable or neither one is.
Well, respectfully, there is a difference just by nature of, as Your Honor was indicating earlier when speaking to my adversary, regarding the severability. So
Well, but
whether
this, if I can, the Supreme Court, I think, indicated in Bruin that the Second Amendment, rights that are conferred by the Second Amendment have to be given the same degree of respect that any other constitutional right does. So I think the severability question, perhaps, is a question about the merits and whether or not invalidating the proper cause requirement then causes everything else to fall as well. But I think the question of the appeal waiver is different. So would you say that the hypothetical the chief asked you about, is that waivable?
Well, I bring up the severability issue only to say that the chief's question involves it's a blanket ban, but that's not what's happening here. That's the only reason.
I understand,
bring that up.
but I think, well, probably one of three things has to be correct, right? Either all facial constitutional claims are waivable, the chief's example, this case, anything else, none of them are waivable, or perhaps maybe there's some way to distinguish between them, although I don't know what it is. So I'm just looking to understand what your position on that is.
Well, the Second Circuit recently, in the Thompson decision, actually addressed some of this question. And there they said the question is not whether defendants have a right not to be convicted of a non-existent offense. It's a question whether defendants, in exchange for valid consideration, are permitted to execute a binding.
So is your view then that all facial constitutional challenges are waivable?
Well, all constitutional protections are subject to well-defined restrictions, and there's no reason to exempt.
I'm sorry, I think that's probably a yes or no question. Either they're all waivable or they're not all waivable.
Well, they certainly do not, they're not covered by the Seaberg carve-outs, but to the extent there is a glaring constitutional issue that comes up at some other points, the court can then use its adjudicative powers there.
Well, wait, so that suggests that blatant constitutional, if you have a really good constitutional challenge, then that can't be waived. But if it's a constitutional challenge where we sort of peek at the merits and we think maybe it succeeds, maybe it doesn't, I'm not sure I understand your position.
Well, here, I think there is a difference in something that imposes a blanket ban, as the chief referenced, and here.
So if New York passed a statute saying that no one in the state, other than a law enforcement officer, may possess a gun in their home or receive a carry license, period, blanket ban, would a constitutional challenge to that be waivable on appeal or not?
I mean, that would certainly fly in the face of the court's decision in Heller.
But would the appeal waiver be enforceable or no?
That would be up to the court to decide. I'm inclined.
Sure,
to
but
say
I'm just asking you for your view on the question.
I'm inclined to say that in such a blanket in such a bold-faced situation be different. But again, the question here is.
But see, that's the problem. You're getting to the merits. Waivers are not about the merits. Right? If you've waived a claim, no one looks at what the merits are. So I understand your answer to be, well, if it looks like you'd succeed, if it really is a constitutional violation, no, you can never waive that. But that's exactly what he's arguing. This is a constitutional violation, and therefore it can't be waived.
But the appeal right is no more fundamental than the right to all sorts of rights that defendants waive, even in the plea context regarding the jury trial, Fifth Amendment.
Then why wouldn't that be true across the board, including in the blanket context that I gave you or the chief gave you?
Well, in the case where a defendant still wishes to plead guilty and still wishes to, and there is a part of the negotiating process which then serves.
Let's assume let's assume that the waiver is clear, freely agreed to, and includes an appeal waiver. I thought I heard you say that a blanket restriction on some conduct, that appeal waiver is not enforceable, but in some other circumstances it is, if we're talking about a constitutional challenge. And I'm trying to understand where you would draw that line and why.
Well, I just note that the court can assess what's necessary to facilitate leading meaningful appellate review should those situations apply.
But that's what your adversary is saying is true here, right? Your adversary is saying that this is a facial constitutional challenge, at least as it applies in this window of time to guns, and that the appeal waiver is therefore not enforceable.
Well, I'd also point out to a large extent, this court already answered many of these questions in its holding in Carrera.
That's about preservation, which is distinct, I think, from the question of whether an appeal waiver is enforceable.
It is, but our position is that if it requires preservation, there's no logical.
So what's your best articulation of what is the through line between waivable and not waivable in our jurisprudence?
Whether it goes to the process of determining factual guilt or innocence. So, for example, in the speedy trial context, as I noted, Seaberg notes that the delay could then cause someone to plead a factually innocent person from pleading guilty. In the cases regarding involuntariness and incompetence, it's the same similar type of concerns. But here, the only question for this court to consider is whether a defendant could make a rational decision to waive his claim in exchange for this offer. He had a...
I don't understand that at all. I'm not trying to be cute about it. I just don't understand the distinction you're drawing. People, I mean, it's documented. People take pleas and waive their rights even when they're completely innocent. So you could argue that he was innocent.
Well, here, to the extent that he was interested in preserving any rights for further review as part of the negotiation process, he could have sought a carve-out in the
But
case.
that seems like it goes too far, because that would apply to any type of claim. You could always say, even with an illegal sentence or anything, you could say, well, this is a good bargain, so I'm going to take it.
And that would be part of a discussion with competent counsel. But to the extent he may have
Well,
wanted...
no, but you agree that there are certain rights that one cannot waive,
Absolutely,
correct?
as recognized by this court in Seaberg.
Even
So
if
you
even if
can't
got
be
a
in
good
that
bargain.
negotiation over something you cannot, well, I guess you could negotiate it, but it's not going to stand up. Why would the prosecutor engage in such a negotiation?
Absolutely. I'm sorry, I may have misspoke earlier. Yes, no, certainly we're not looking to go against the court's core holdings in Seaberg. But to the extent that a defendant does wish to preserve this claim for appeal, he can seek a carve-out. In fact, in this court's decision that addressed whether the constitution of a statute survives a guilty plea, this court specifically referenced a case in which someone had sought. And I would also just note that, this, to the extent that there's the split, the first department and the second department are both in agreement regarding the whether this can be waived. The third department has not addressed this issue, but they ruled that it was doubtful that a challenge to the constitutionality of the statute would fall within the narrow category of surviving the appeal waiver. And again,
So your white light is on. You want to address the other issues other than waivability?
absolutely, yes. So the defendant deprived the state of an opportunity to assess his eligibility for a license And permitting such an end run incentivizes gun owners to flout licensing laws, increasing risk to the public and of gun-related violence. Bruin specifically said states can have a licensing scheme, and the defendant shouldn't be able to raise his challenge without first trying to go through this lawful process. The state has a compelling interest in completing the background check. The Second Amendment is limited to, as is explained by the Supreme Court repeatedly, the Second Amendment is a right for law-abiding, responsible people. And here, a defendant he was caught, this case came up, he was caught with a gun in the midst of a domestic violence investigation. He had an armed robbery conviction out of Georgia.
So what would have been the point of applying for the license if you're arguing he never would have gotten it?
Well, that's to not require someone to go through the process has significant public safety implications, as Your Honor noted in the Garcia dissent. By choosing not to apply for a permit, he deprives the state of an opportunity to assess his eligibility for a license. Permitting this end run incentivizes gun owners to flout the licensing law, increasing the risk to the public of gun-related violence. Same thing applies here.
So what do you think he put at issue? Just the proper cause requirement, proper
Yes.
cause plus good moral character, everything in the statute? And what do you think, how do you think this is supposed to work? Not in this case, but in a future case.
Well, in this particular case, and certainly there are defendants who put other things in the statute, here he only puts the proper cause requirement in.
And so where would that leave us if we were to get to the merits?
Well, the proper cause requirement is easily severable from the remainder of the statute. In fact, the legislature made very clear its desire to exempt that portion by rewriting the statute and rather than striking down all of gun licensing rules, upholding the remainder.
But he was subjected to it, and so I think his argument is that if we were to reach the merits, his argument is the Supreme Court has said it's invalid. I think that's correct. And so since it was part of the licensing scheme, and the licensing, and having a license is an affirmative defense to the offense, that he can't, his conviction can't stand.
Well, by the time he was arrested, I'm sorry, may I answer?
Of course.
By the time he was arrested, the statute had already been, the Supreme Court had already struck down.
Yes,
It was just simply
that's correct.
awaiting so here, he didn't even apply, and here we're also talking about just the proper cause for concealed carry. This is a defendant who never even went through the process of applying for even a restricted license. And that was something that was noted by the court in its decision denying his dismissal motion. So the proper cause requirement wouldn't have even been a factor. And especially given his background, the safety interests require that he go through the process and that litigants should not be subject to self-help remedies to the detriment of public safety. To the extent that any individual does want to challenge the constitutionality of the gun licensure process, they should go through the process and if it doesn't go to their way, they should do what the plaintiffs in Bruin did and apply civilly rather than endanger public safety.
Thank you.
May it please the Court, Matthew Keller for the Attorney General in defense of the statute. I'd like to address the Court's questions in terms of what I guess is the order of importance. Turning to the
Would you
appeal.
start, on the appeal waiver, what is your response to the question of whether all facial constitutional challenges are subject to waiver, including some, blanket ban that might appear blatantly unconstitutional?
We think that this Court should find that they're all waivable.
They all
And
rise or fall together.
They all rise or fall together, but I will note, I think that there's only a facial challenge preserved here, and so the Court doesn't really need to reach that issue. There's only one type of claim that's preserved here. In terms of you know,
I'm sorry, I don't think I've followed that.
well, he challenged.
No, I understand there's only a facial claim here, but why wouldn't we have to reach the question of whether a facial claim survives a waiver?
Oh, I think you have to reach that question, Chief Judge. What I meant was the distinction between facial challenges and as-applied challenges. I don't think it's necessary to confront the distinction because the distinction isn't presented here. There's not both types
But
of claims raised.
I took the people to be suggesting that perhaps where there was a blanket ban that would not be subject to a waiver, but some other set of facial challenges would be waivable. And I take it you're saying every facial challenge is subject to a waiver, regardless of its apparent merits if we were to peek at them.
Yeah, that's our position. Now, it's important to note, and
So New York passes a law saying it's a criminal offense for an African-American person to vote, and somebody's prosecuted. They can waive that.
no, Your Honor, that's not our position, but that is not this case because he is not challenging.
Why isn't that this case?
It's not this case, Your Honor, because he's not challenging the state's very power to prosecute his criminal conduct, which here, to be clear,
He
was the
is, though.
unlicensed possession of a firearm.
I think that what he's arguing, and I'm sure perhaps, he'll correct me if I'm wrong, is that because, and you, I understand, disagree on the merits, but I think he's saying, in light of Bruin's invalidation of the proper cause requirement, a statute which has as its affirmative defense possession of a license subject to that regime is unconstitutional, at least as it applies to gun possession.
Your Honor, that may very well be his claim, but that is not a challenge to the state's very power to prosecute him for his conduct. What it's a challenge to is a feature of the state's permissible regulation of his conduct. And the two things are different. And I'll point out.
But I can change my hypothetical to require you to get a license for voting, and to get the license for voting, you have to be white. I can make this on all fours.
And again, Your Honor, but we think that distinction is crucial here. If this court is presented in the future with the case where there is a statute which the state absolutely has no power to prosecute,
And is that because
that might be the place to draw the line, but this is not that case.
Is that because it's an affirmative defense, or is that because you think it's not a good argument on the merits?
It's because we're not peeking at the merits. That might be one way the
Okay,
court
so-
could determine
so
it, but I don't think this way
What is,
requires the court to do it. I think it is undisputed in this case that the state had the power to prosecute and punish Mr. Johnson for possessing an unlicensed firearm.
Why do you
He's just
say that?
complaining about a feature of that regulation, a single feature which frankly wasn't even in effect at the time of his arrest.
if the statute instead included some requirement that that the state prove that the defendant lacked a license, so it was not an affirmative defense, but it was an element, would that change your view?
No, Your Honor, because the state would still have the power to punish him, even though it perhaps had gone about that in a constitutionally problematic way.
I'm not sure I
It still had
understand,
the power to punish him.
Not sure I understand that point.
Okay, maybe, I'm sorry.
I mean-
I apologize. Let me try again to get it out. He cites in his brief cases like Loving v. Virginia and Lawrence v. Texas, which clearly dealt with the state punishing conduct. It under no way had the ability to punish.
In no way, because the conduct that sought to be punished was unconstitutional.
There was a substantive due process right to engage in that conduct.
Because
It
the
does not-
conduct was constitutionally protected. And I believe that they are arguing that the conduct here is likewise constitutionally protected, and that absent some permissible restriction on that, which they say the regime did not put in place, that it's no different. So that's why I'm trying to understand
Respectfully,
the
Your
basis
Honor,
for the distinction.
Respectfully, Your Honor, that's not his claim here. He says it in his brief himself several times. We are not questioning the state's power to punish the unlicensed possession of a weapon. He's not raising that claim here.
But
if he
if
was,
the
it might be a
license-
different case.
But counsel, if the licensed possession of a weapon was the subject of this bill that we've crafted here that says no one except a law enforcement officer can carry a weapon, how does that, can you seriously argue that that doesn't affect the state's right to prosecute unlicensed possession of a weapon?
If you're saying a very simple licensing regime where it said, in order to obtain a license, you have to be a law
I
enforcement
mean, the same
officer.
system we have here. Assume that we have the same penal law provision that criminalizes unlicensed possession of a weapon, and we also have a licensing statute. But the licensing statute says no one but a law officer can license a weapon in the state of New York.
In the case of just a single licensing provision, I think it might be a harder question to answer. But here, we have a multifaceted
said they all-
licensing
they
regime,
all
most
rise
of
and
which
fall.
the Supreme Court has said is totally proper.
So that would not be a waivable argument.
In the case of a single provision licensing scheme, it might be hard to draw the distinction between the licensing provision itself and the state's power to prosecute.
Well,
But I don't think that's the case here
Suppose
at
you
all.
had the same licensing scheme here, but also it defined proper cause as being employed as a law enforcement officer.
Yes, Your Honor.
You have
And-
multi-factors then.
And if I understand Your Honor's question correctly, there were no other bases
No,
for the
that you
denial of
all-
a license.
No, the existing provisions would also be there. So good moral character, no prior felony, all those other things are still there. All I've done is change the statute to define proper cause as being employed by a law enforcement
If-
agency.
If the defendant had applied for a license, if that provision had been the basis for the denial of a license, meaning he had properly, invoked standing to raise it, and
I'm just
then
focusing
he
on
could raise it.
waivability for a moment, not standing.
Again, I think even in that case, Your Honor, because it didn't go ultimately, the state, if it had a proper licensing provision, could punish the conduct. I think he should be able to waive it. Now again, and if I could briefly address the broader through line, as Judge Canataro put it, the test cannot only be the public interest. Defendant relies on the broadest language from Seaborg in this court's decisions that claims implicating the public interest or those that transcend the defendant's own interest may not be waived. But he ignores both the clarifying language of this court's decisions and their holdings. The public interest cannot be the test. All
Can I just
constitutional
ask
claims
you-
affect the public interest.
I know
in
your
some
light
way.
is on. If I could ask you one question about the merits?
Yes, Your Honor.
I was struck, I looked at Antonyuk, and it looks to me like the state briefed the question of the application of the history and tradition test, yes?
Yes, Your Honor.
And not here. So I understand that you argue that the waiver is valid and that there's no standing. But if we were to reach the merits, why do you think that test is not in play here, as indicated by the absence of a brief that addresses that test?
I don't think, and on this very subject, I think a useful guide for this court might be the Fry test, where once a court determines certain evidence to be admissible, generally accepted under scientific principles.
If we think there is a
It
merit,
doesn't have to be repeated. They don't have to reinvent the wheel during every case. The Supreme Court has said a lot of these provisions.
so just so I'm
Yes, Your Honor.
clear, if we think that the merits are in play here, and I understand you argue there are multiple reasons why they're not, but are you suggesting then that we would go look at your briefs in another case? Are you suggesting that the history, I'm just trying to see where you are on this question.
Well, Your Honor, I guess it depends which provisions you're seeking to uphold. I think it's already been conceded.
We
that
wouldn't
only
be
Bruin-
seeking to uphold anything, I think.
I'm sorry, Your Honor. I guess it depends which licensing provisions you were seeking to determine the constitutionality of. Here, I think the court need look no further than Bruin itself. Its decision in Cabrera, where even though it didn't reach the merits, it said Bruin did not reach anything but the proper cause standard, and perhaps the Supreme Court's
But I
decision
don't
in
think
Rahimi.
Bruin addresses, but if you have a different view, tell me. I don't think Bruin addresses the question of the consequence of invalidating the proper cause requirement, right? So is that a function of severability? Is that a function of application of the history and tradition test? How would one resolve, if it was properly presented, that question?
So in Rahimi, which is the Supreme
Yeah.
Court's latest decision on the Second Amendment, it said, when legislation and the Constitution brush up against each other, a court's task is to seek harmony, not to manufacture conflict. This court has already harmonized Bruin with New York's licensing regime in Cabrera when it said, even though it wasn't a holding.
I don't think
it said it-
Cabrera reaches any conclusion on the question of what flows from the invalidation of the proper cause requirement.
It said, in Cabrera, the court said Bruin did not address any other aspect of New York's licensing scheme other than the proper cause
Which leaves the
provision.
question open, it seems to me, yes?
So the question, well, Bruin didn't address it, and I don't think the court needs to go any further than Bruin did. I think the court should hold, as consistent with all of the appellate division departments to reach the issue,
But Bruin,
that everything
but
else survives. Yes, Your
Bruin
Honor.
sets out the test to determine whether or not a provision is constitutional.
It does, Your Honor.
And is not, in part, whether you think it's waived or you think he has standing, put all that aside, it is not in part his argument that if you're looking at that test, the state didn't carry its burden to show that it was indeed constitutional.
I think if he's challenging something that the Supreme Court in Bruin didn't specifically say was okay.
No, but it set out the test of how one determines it. The only issue in the case was the proper cause requirement, so to address that requirement.
And in this case, the proper cause requirement was no longer in play. And so anything that he challenged, if he had challenged other provisions of New York's licensing law, the state may have been able to come forward and give the historical tradition evidence, but he didn't. And so then we're back to Cabrera, and it's unpreserved.
Thank you.
This is a case, of course, that is about constitutionally protected conduct. Mr. Johnson alleged below that he was engaging in his Second Amendment right, which New York State simply did not recognize at the time. And there really was no dispute here that he possessed this firearm for self-defense. He was an Uber Eats delivery driver who carried a gun in his moped for self-protection. He was not alleged to have used, threatened, or even removed the gun from his moped in any way.
Could I ask you, I just want to make sure I make good use of your time.
Yes.
You say in your reply brief that at a minimum, the court should remit to the trial court for a hearing. What would that consist of? What would the questions be that would be presented in your view?
The question presented would be the constitutionality of the licensing scheme that existed at the time Mr. Johnson was arrested. And
What exactly does that mean, the constitutionality? You did not challenge in the first instance any specific provisions other than noting that the proper cause requirement had been invalidated. I realize in your appellate division brief and here you identify some other specific ones, but would that mean that you would think that you could identify a range of provisions and go through the history and tradition analysis? Would the question instead be whether or not the invalidation of proper cause prohibits any conviction under the penal law? That's a different question of law, I think. What would be before the court?
Right. So the invalidation of proper cause did carry with it the significant consequence that an individual could not be prosecuted merely because they didn't have a license under that regime.
In your view?
In our view, and that flows directly from Shuttlesworth, and I think it's really important to note
But if that's right, what is it you'd be asking the trial court to do? What's the hearing?
So to the extent that this court finds that proper cause was severable or not in effect at the time, a hearing would address the constitutionality of the remainder of the licensing scheme under the proper rubric. Because here, the court did not do that. The court found that—
Why would you be allowed to raise additional challenges to specific provisions that you didn't raise in the first instance in the motion to dismiss?
Because we have an explicit finding here by the trial court that every other provision in New York's licensing was—
Well, whether we read the trial decision that way or perhaps read it differently, is that what that would hinge on for you? We'd have to read the trial decision as some broad holding?
Well, it was, Your Honor, and I think there's a major issue with New York's licensing scheme, both with proper cause and with good moral character. Where at the heart of New York's licensing, prior to the effective date of the new legislation, is really subjecting a constitutional right to the unfettered discretion of a government official. That's exactly what Shuttlesworth and Staub—
But that's not what I thought your answer was to the question of what is it that you could raise when you get back on this remand to the trial court. You answered with a much more general, the validity of the entire licensing regime, which I assumed meant that you read Bruin as invalidating the entirety of the licensing regime.
So Bruin did invalidate the public carry licensing
No question.
regime.
What about the rest of it? Because that's what we're struggling with.
Right, so for someone,
Well, it invalidated the proper cause requirement.
Proper cause, yes.
it invalidated proper cause in every case, but I think what Shuttlesworth and Staub in those cases stand for is that someone cannot, it's a standing and a merits holding that flows from those cases, that somebody cannot be prosecuted merely because they didn't submit
But that, to me, it seems, is about the question, what are the consequences of Bruin's invalidation of the proper cause requirement for a conviction? That's a different question, I think, than let's go through all the other aspects of the regime as it stood on that date and examine whether those pass history and tradition. But maybe I'm misunderstanding.
So I do think that's right. And Bruin itself notes that party presentation in a given case might dictate a certain result. Here, the way I read the prosecution's response to Mr. Johnson was to really be arguing that just because Mr. Johnson did not submit even to a background check, for example, that he could lawfully be prosecuted for exercising his Second Amendment rights. And that's really what Shuttlesworth, I mean, that's exactly what happened in Shuttlesworth. There was a requirement that was really akin to a background check requirement in that case, where somebody had to submit a written application, they had to denote how many people would be involved in the protest, and the Supreme Court noted that licensing generally could be valid, that the government has a public safety interest in regulated public streets, in Shuttlesworth as well. And nobody was, it was not relevant in that case that Reverend Shuttlesworth had failed to submit to a
Counsel, I
background
see your red
check.
light is on, and with the Chief Judge's permission, I'd just like to go back to something just so I'm clear, and forgive me if you've answered this. But has this court ever held that an issue both needs to be preserved and is non-waivable?
Yes, Your Honor, voluntariness, competency as well.
So we've held that voluntariness needs to be preserved, but at the same time is non-waivable?
Correct, Your Honor.
So if I don't preserve at my non-voluntary plea that it's non-voluntary, then I can't appeal it?
There are exceptions to the preservation requirement that might get at that issue, but as a general matter, yes, it is a claim that needs to be preserved. And this court has made clear that
So a non-voluntary plea claim has to be preserved at that time?
if there's a practicable opportunity to do so, yes, it does.
During the non-voluntary plea?
That's this court's articulation of the preservation rule in those cases.
Other than the non-voluntary plea preservation, have we ever done that?
A request for competency, I believe, would also need to be preserved. And the reason why, it's because there needs to be.
If the request for, just so I'm clear, and I'm asking, a request for competency, if it's not made, a later claim that you've waived that is not going, that you've waived is not going to be heard then. You can waive it, even though.
I believe you cannot waive those claims, but you
even
would.
if you've never preserved it. I never asked for competency hearing.
Right, so there does have to be a sufficient record for review, which is why preservation is important in that context. That's why preservation is so important in the constitutional context, as this court made clear in Cabrera. But nothing in Cabrera or David or any of this court's prior decisions, Bauman and Sons as well, requiring preservation of constitutional challenges really speaks to a lack of significance or a lack of public interest in the right. There's simply different interests at play in both contexts, as I think.
But I just, my question is going to some of the questioning before, which is this hypotheticals, such an outrageous violation, but we would still require preservation of it. So that would be kind of the analogy here. Like, it's so bad, this is so outrageous, this facial challenge, but we still require you to preserve it. That seems to strike me as inconsistent with a non-waivability approach.
To be frank, Your Honor, think that that's more consistent with perhaps a critique of this court's preservation rule in the constitutional challenge context,
So
but I
Are you
think.
asking us then to revisit our requirement that this be preserved?
No, I'm not, precisely because, as this court has explained in Cabrera, there's a rationale for that rule that frankly is in opposite to the waivability context. The
Well, Seaberg
rationale.
identifies a rationale for the rule on appeal waivers.
Yes, it absolutely.
It's actually along similar lines, I think.
It's the most broadly speaking, the rationale in Seaberg, and this is Seaberg at 7, is the integrity of the criminal justice system as a whole. And I submit that the state's arguments here that really this is just focused on the process used to churn out guilty pleas, and as long as that appears fair.
Can you address that point that, that you're focusing too narrowly on the language in Seaberg, that you've cherry-picked this particular language, but there's clarification in the case law and in Seaberg that shows that public interest is much more narrow than what you argue?
So the public interest language that
Yeah.
I've cited to about transcending the individual interest in appellate review, that comes from Muniz. That's been cited recently. I mean, the last waivability challenges that this court heard in Brown, the Attorney General cites to the court found that that claim was waivable precisely because it's and that was a claim about the right to speak at sentencing. The majority found that that was waivable precisely because it's such an individualized claim. Recently, in the Silva Santos case in Judge Wilson's dissent, there was a discussion of waivability with public interest as the standard. So, and I don't think the disagreement in that case was about the waivability standard. It was about perhaps the applicability of that. So that's the standard that's been most recently used. But I think I'll point to constitutional speedy trial as an example of a claim that really demonstrates that this claim ought to be non-waivable at all. I think, as Your Honors noted, if there's the concern that even the mere risk of an individual who's factually innocent based on the time that's elapsed might be forced to plead guilty is enough to demonstrate that an issue should be non-waivable, then here we have a claim that someone in fact should not be prosecuted in the first instance, is perhaps languishing in prison for constitutionally protected conduct. In that situation, the Supreme Court has said, Welch versus United States, right, which we cite in our briefing, that finality interests are at their weakest, and it's a fundamentally unfair decision to thrust on any individual defendant, whether to even consider having to take on more time to vindicate what's a collective interest.
Thank you.
Thank you.